It's a strange and troubling thing in a country as prosperous and progressive as ours, that a woman at risk can do everything she's been told to do: seek help, speak truth, place her trust in the law, and still find herself dead at the hands of her own partner wielding a bloody weapon in what can only be considered a completely avoidable murder. Bailey McCourt is one such story. She wasn't a statistic. She was a young mother with 2 young children right in my community of Cloverdale. To those who loved her, she wasn't a headline. She was the center of a home, a woman trying to build a safe life for her family. Like so many others, she found herself in a relationship that became dangerous over time. There were threats, there was violence. At one point, there was strangulation. One of the clearest indicators that the risk had escalated to a level that should never be ignored. On the morning of July 4th, Bailey's former partner stood before a court and was convicted of assaulting her. The system had, in that moment, all the pieces in front of it. It had the history, it had the violence, it had the pattern that had been building over time, and yet despite all of that, he was released. There was no requirement to step back and ask whether this was something more than a single offense. No mechanism that treated violence against an intimate partner as fundamentally different from any other assault. No tool that required the court to fully assess whether Bailey was still in danger, even after a conviction had just been entered. Because under the law as it stands, we do not distinguish in any meaningful way between a violent act against a stranger and a violent act against someone in an intimate relationship. A relationship built on trust, proximity, and in many cases, vulnerability. And when we fail to make that distinction, we fail to recognize the very real and very documented risk that comes with intimate partner violence, particularly when it escalates. And so just hours later, Bailey was in a parking lot, going about what should have been an ordinary part of her day. And it was there, in that ordinary place, in broad daylight, that her attacker found her and murdered her. She knew this could happen. She begged to be protected, but the law, as it is written, ensured that the warning signs were ignored and the inevitable happened. And when we look back at that day, the question isn't simply how this happened, but why there was no legal mechanism strong enough to interrupt it. Why, after a conviction, there was no ability for the court to say, we need to take a closer look at this individual. We need a proper risk assessment. We need to determine whether releasing this person puts a woman's life at risk. Bailey's case is not just a tragedy. It is a clear example of a gap in our law, a gap between what we know about intimate partner violence and how our system is currently structured to respond to it. Now, when we step back from Bailey's story, difficult as it is, we're forced to ask ourselves a larger question. Was this truly an isolated failure? Or is it part of something that we have been seeing for far too long and not just willing to make the necessary changes to protect women at risk? Dr. Wendy Ojala, Assistant Professor of Criminal Justice at Athabasca University, has spent years listening to women, many of them particularly vulnerable as new immigrants, who have walked this very path. Not in theory, but in lived experiences, in stories that when placed side by side begin to look far less like exceptions and far more like a pattern we can no longer ignore. What she hears time and again are not stories of women who failed to act, but of women who did exactly what Bailey did. They reported, they sought help, they tried to leave, but just like with Bailey, risk wasn't considered in the context of what had already happened and what was increasingly likely to happen next. And for many women in the South Asian community, the path to even reaching that point is far more complex than the system is designed to recognize. Their particular cases are often complicated by family honor, language barriers, and coercive control inside the home. A system like ours, seemingly built to protect the perpetrator of intimate violence, is very dangerous, especially for women of vulnerable minorities. And so, when we consider what happened to Bailey, we cannot look at it in isolation. It fits into a pattern that's already been identified, already been studied. The knowledge is there. Our laws are ignoring that knowledge. And while research, like Dr. Ojala's, helps us understand the pattern, it's often outside the government, in community spaces where we see just how real and immediate this issue is for women living through it. Last year, I attended a fundraiser on behalf of the CAR movement, founded by Gurpreet Kaur and supported by leaders like Manjot Kaur. The CAR movement is a survivor-led network that supports women facing abuse by connecting them to real-time help, like shelters, legal aid, and counseling, while also working to break the culture of silence around domestic violence, especially in the South Asian community. I went expecting to hear about advocacy, about awareness, about the kind of work many organizations are doing in this space to support women. But what I heard that evening has stayed with me, because it wasn't abstract or theoretical. It was story after story of women who have lived through violence, who tried to seek help, and who, in many cases, had found themselves navigating systems that were slow or difficult to access at the very moment they needed them most. What struck me was not just the severity of what women endure, but the common thread running through their experiences, the sense that they were often left to carry the burden of their safety on their own shoulders, feeling helpless and afraid because their lives are not as valued as the men who perpetrate this violence. The CAR movement has built something remarkable in response to that reality. They've created a network that responds in real time, connecting women to shelters, legal help, counseling, often at the very instant that they are reaching out. What they are seeing day after day reinforces what we know. These are not isolated stories. They are part of a pattern, one that continues to unfold in communities across the country. Tragedies are playing out time and again due to a lack of law that protects these vulnerable women in their moment of need. When we place these stories side by side, Bailey's life and loss, the careful work of women like Dr. Ojla, who studied these patterns, and community voices like the CAR movement, rising from what they see in reality every day, it becomes impossible to pretend that we do not understand what's happening. What this bill asks us to do is to finally align our legal response with what we already know to be true. It asks us to recognize in law that violence within an intimate relationship is not the same as violence between strangers, that it carries with it a level of risk, of proximity, that makes it more dangerous, not less. This bill would begin to correct that by naming the reality for what it is. It would create a distinct offense that acknowledges the nature of intimate partner violence. Now it goes further still. It recognizes that when the ultimate act of violence is committed within a pattern of coercive or controlling conduct, when a life is taken by someone who's used that pattern of control and fear as a weapon, it must be treated with the full weight of the law. To name that act as first-degree murder is not merely a question of punishment, it's a statement of clarity, a refusal to look away from what intimate partner homicide truly represents. The law has long recognized that killing in the context of other serious circumstances warrants elevation to first-degree murder. This bill extends that same principle to the killing of an intimate partner where coercive or controlling conduct is present, because that context is not incidental to the crime, it is the crime. This bill would ensure that where a person has already been convicted of an intimate partner offense within the past 5 years, or is already at large on a release order related to a prior intimate offense, a peace officer cannot simply release them at the scene. That decision must go before a judge. It's a safeguard built for moments like Bailey's, where the history is already there, where the pattern is already documented, and where the ordinary process of release is simply not enough to meet the gravity of what's in front of the court. Bailey McCourt should still be here. That's the simplest, most honest thing that can be said. Her children should still have their mother. Her family should not be carrying this weight, nor should they be the ones who must now stand before us and ask that we do what should have been done already. We cannot give Bailey back to her children, but we can decide here and now that her story will not end in silence, and that from it will come a measure of protection for those who are still, even today, waiting for the system to recognize the danger they are living with. Let's pass this bill. Let's act with the seriousness this moment demands. And let's ensure that when the warning signs are there, as they so often are, we don't look back once again and say that we knew and didn't act.